Greetings to Dr. Hanim and my fellow friends. Today, I am Leshni Anak Perempuan Krishnan from Group 2 will be presenting Polluter Space Principle. My groupmates are Muhammad Afiq Adam, Muhammad Aizat bin Nizam Shah, Nurul Anis binti Zulmi, and Nia Afia Sikau.
Today we are going to look at 5 things. First, introduction. Second, purpose of PPP. Third, current issue in Malaysia. 4, comparative study, looking at ASEAN with EU and also Australia, India, UK and Malaysia. And the last one is conclusion.
First and foremost, I will be explaining on the concept of polluter pays principle. The polluter pays principle is an important basis of international law. This is because this principle enables environmental factors being included in the valuation of assets and services, adopting the polluter pays, also known as user pays principle, where those who generate pollution and waste should bear the cost of containment, avoidance, or abatement. The first mention of this principle at the international level is to be found in the 1972 recommendation by the OECD Council on guiding principles concerning international economic aspects of environmental policies. The polluter pays principle has also been reaffirmed in the 1992 Rio Declaration at Principle 16. As a summary, the polluter pays principle is widely acknowledged as a general principle of international environmental law, and it is explicitly mentioned or implicitly referred to in a number of multilateral environmental agreements.
I'll be presenting about the purpose of polluter pays principle. For the last 2 decades, polluter pays principle has been practiced in many different forms in different cultures and economic systems. It is applied through a variety of economic instruments such as taxes and charges, emissions trading, as in cap and trade, deposit refund scheme, liability, and insurance. Today, the polluter pays principle is one of the core principles of sustainable development. It is also one of the fundamental principles governing modern environmental law and policy, underpinning most of the regulations imposed on potential polluters affecting land, water, and air. The polluter pays principle is often applied as a liability and compensation mechanism, which can also act as an incentive for potential polluters to implement whatever measures deemed necessary to prevent potential pollution, comply with regulations, and avoid additional costs. As a main function of the principle, the OECD recommendations specify the allocation of costs of pollution prevention and control measures to encourage rational use of scarce environmental resources and to avoid distortions in international trade and investment. The polluter should bear the expense of carrying out the measures decided by public authorities to ensure that the environment is in an acceptable state. The OECD also applies the extended producer responsibility in managing pollution, which was first introduced by Thomas Linkervis in his doctoral dissertation. The OECD defines it as a concept where manufacturers and importers of products should bear a significant degree of responsibility for the environmental impacts of their products throughout the product life cycle, including upstream impacts inherent in the selection of material for the products, impacts from manufacturing production process itself, and downstream impacts from the use and disposal of the products. Under Principle 16 of the Rio Declaration on Environment and Development, it stated that if environmental costs are not internalized, or if state subsidies are given to polluting industries, or if preventive measures are paid by the state, this could lead to distortion of international trade and investment. Thus, due application of the principle also protects economic interests.
In March 2019, Sungai Kem Kem Pasir Gudang Johor was reported to be polluted due to illegal chemical waste dumping into the river. This illegal dumping releases toxic fumes and affected thousands of people living in the near vicinity of the river. It was reported that there were at least 6,000 victims affected by the river pollution. 2,775 were hospitalized and 110 schools were closed, as the victims of the river pollution were mainly school students. This incident worsened in April as the chemical waste passed through two other rivers tributaries to Sungai Kim Kim, and it was complained by the residents that both rivers turn black and produces foul stench. The sampling of Sungai Kim Kim identified high level of hazardous chemicals that are extremely dangerous to a person's health. This could cause the victims to suffer respiratory problems, skin irritation, and the possibility to develop chronic illness. It was also reported that some of the chemicals are carcinogenic, which can cause cancer and may affect internal organs such as causing liver damage. Under the EQA 1974, the maximum fine for the perpetrator is Rm 500,000 for discharging waste into Malaysian water according to Section 29 EQA 1974, and Rm 100,000 for polluting the water according to Section 25 EQA 1974. The offender in Sungai Kim Kim would probably be fined up to Rm 600,000 and no more than that. It was reported by the state government that a total of Rm 6.4 million were needed to clean the river, with further costs expected to balloon up to Rm 10 million. The federal government had also allocated Rm 8 million for river purification works and ordered various agencies such as the police, the military, to provide support in the affected area. The Sultan of Johor himself donated Rm 1 million for the cleanup activity, while urging for an immediate action against the perpetrators involved in the pollution. This situation is a ridiculous one, as the perpetrators are released after paying Rm 600,000, while the state government and the federal government still need to spend millions to cover the cleanup expenses. The situation becomes more ridiculous as we know that the government's fund came from the taxpayers' money, and the taxpayers are the innocent citizens of Malaysia. The taxpayers are innocently helping the perpetrator to pay for the perpetrator's mistake with the taxpayers' hard-earned money. This situation is the exact reason why there is a dire need for implementing the polluter pays principle in this country. We cannot afford to keep spending the taxpayers' money to cover up expenses to mend the environmental disaster caused by the irresponsible perpetrator. It is time to hold the wrongdoers accountable for all the expenses caused by them. Section 47 can be shortened to mean that anyone who pollutes the environment can be asked to pay the full amount of expenses in carrying out activities of removing, dispersing, destroying, or mitigating the pollution. Meanwhile, polluter pays principle means that anyone who pollutes the environment should bear all the expenses in controlling, mitigating, or cleaning up pollution caused by the polluters themselves. Now it can be said that this provision is a split image of the polluter pays principle. As defined earlier, polluter pays principle requires the polluters to bear all the expenses in controlling, mitigating, or cleaning up pollution caused by the polluters themselves. Section 47 is clear that if the perpetrator is the cause of the pollution, then he must be the one who need to take money out of his own pocket to reverse the condition of the environment. It is often said that our country has not yet implemented polluter pays principle, but this is not entirely true, as those who professes this opinion might not be aware of the existence of Section 47 of the EQN 1974, which is very similar to the desired principle. Maybe the right thing to do now is to confirm with the legislative authorities whether this provision is really a polluter pays principle after all. The next thing to do after that is to convince the public of the effect of Section 47 and that the desired principle has long been implemented into our own law.
PPP has been recognized in many international conventions. For example, the Helsinki Convention on the Protection of the Baltic Sea and the Protection of the Mediterranean Sea against Pollution. We can say that since this principle has been introduced in many countries, it is a sign of growing international acceptance for PPP. Although this principle has been highlighted in many international conventions, there is no unanimous opinion on whether this principle should be considered as either a general principle of law or as a rule of customary law as provided in Article 38 of the Statute of International Court of Justice. In EU law, PPP has been mentioned in the EU Treaty. This article, however, does not extensively elaborate the principle of PPP. The initiative of including the principle in the EU Treaty means that this law is legally binding for all EU legislators with a restricted judicial control. An example of the codification of this principle is in the French Environmental Code, where Article L1101 says that the polluter pays principle, according to which the cost of measures carried out to prevent, reduce and control pollution have to be borne by the polluters.
Now into the relation of ASEAN and the polluter pays principle. So the development activities in any countries will somehow affect nearby countries. We must understand that sometimes the action done by our nearby countries also might affect our environment. For example, the transboundary haze caused by forest fires in Indonesia is affecting nearby countries such as our country Malaysia, Singapore and Brunei. ASEAN working together to closely curb and administer the problem of environment in their respective country and also for the benefit of ASEAN community as a whole. The representative of each country regularly meet to discuss on the environmental issue and problems and also suggesting and finding solutions together. And in relation to the PPP, there is a recognition of ASEAN on the polluter pays principle, as there was a seminar on polluter pays principle held in Manila, Philippines in 1997. This showed the ASEAN community recognized the use of PPP as one of the ways to reduce and mitigate the environmental problems. However, it is still up to the respective country whether they are applying and implementing this said principle into their domestic laws and enforcement.
Now, we'll be looking at the comparison between ASEAN and the EU countries. For EU countries, there is a legal provision under Article 191 Clause 2 of the EU Treaty, which stated that Union policy on the environment shall aim at a high level of protection, taking into account the diversity of situations in the various regions of the Union. It shall be based on the precautionary principle and on the principle that preventive action should be taken, that environmental damage should as a priority be rectified at source, and the polluter should pay. In this context, harmonization measures answering environmental protection requirements shall include, where appropriate, a safeguard clause allowing member states to take provisional measures for non-economic environmental reasons subject to a procedure of inspection by the Union. While there is no special provision that discusses environmental issues for the ASEAN countries, however, ASEAN has come together as one and worked together in promoting the importance of environmental cooperation for sustainable development and the unity as a regional. Although EU countries already have a provision for environmental matters, there is also secondary legislation that exists for certain EU countries. For example, France has its own set of environmental laws under the French Environmental Code. ASEAN countries are said to have no special provisions on the environment, but have provisions according to their respective countries. Among them, Malaysia has the Environmental Quality Act 1974, Singapore has Environmental Protection and Management Act, while the Philippines has RA 8749 Clean Air Act of 1999. For the EU, we can refer to the case Commission of the European Communities versus Ireland. By its application, the Commission of the European Communities requested the court to declare that in not putting in place the criteria and detailed rule for the use of the fishing quota allocated to it, by failing to ensure compliance with community rules on the conservation of aquatic marine living resources by the monitoring of fishing activities, appropriate inspections and the recording of catches, inspections and other control as required by the relevant community regulations, by failing to prohibit provisionally fishing by vessel flying its flag or registered in its territory when the quotas allocated to it were deemed to be exhausted, and by failing to initiate administrative or criminal proceeding against the masters of vessel infringing the regulations. Ireland had failed to carry out the obligations imposed on it by Article 9 Clause 2 of Council Regulation number 3760/92 establishing a community system for fisheries and aquaculture, and by Articles 2, 1 and 31 of Council Regulation number 2847/93 establishing a control system applicable to the Common Fisheries Policy. Ireland argued that if the corrections to the data transmitted to the Commission were taken into account, the percentages by which the quotas had been exceeded were very insignificant. The court held that, if corrections into account, the fact nonetheless remained that the quotas for the haddock and anglerfish stocks had been exceeded. While for the ASEAN, we may refer to the transboundary haze in Southeast Asia, commonly caused by illegal forest fires in Indonesia. In this case, we can see the neighboring countries such as Singapore, Malaysia and the Philippines have worked together to ensure that this pollution problem can be addressed through the implementation of international cooperation projects involving cross-border haze programs, sustainable implementation of forest management and peatland conservation.
The polluter pays principle, or also known as the PPP, is the commonly accepted practice that the costs of pollution should be borne by those who cause it. As we can see, there are rapid development processes of manufacturing industries in both Australia and Malaysia, along with the rest of the world, that resulted to increasing amount of industrial and hazardous waste generation, and it is recognized that industrialization has economic, environmental and social trade-offs. There are laws relating to the protection of environment in Australia and the administration of the polluter pays principle in Australia. Concessional provisions pertaining to the prevention and cleanup of contaminated land are contained within the same income tax division dealing with capital allowances. In Australia, the Environment Protection and Biodiversity Conservation Act 1999, or also known as the EPBCA, is the federal government's central piece of environmental legislation. It provides a legal framework to protect and manage nationally and internationally important flora, fauna, ecological communities, and heritage places defined in the EPBCA as matters of national environmental significance. Pollution, however, is a state matter, with each state and territory having a form of environmental protection legislation. In New South Wales, there is another legislation also known as Protection of the Environment Operations Act 1997, where pollution is categorized as water, air, noise, or land pollution, and each is individually defined. Land pollution or pollution of the land is defined as the release of any solid, liquid, or gaseous matter that causes or is likely to cause degradation of the land that results in any actual or potential harm, loss, or property damage. Apart from that, the term pollution is statutorily defined in the Western Australia's Environment Protection Act 1986 to include direct and indirect alteration of the environment to its detriment or degradation. The principal applicable taxation legislation is the Income Tax Assessment Act 1997, also known as the ITAA 1997. There are three major sets of provisions dealing with the cleaning up of and or rehabilitation of contaminated land. The provisions dealing with land rehabilitation are the mine site rehabilitation, the land degradation, and the environmental protection provisions. These differ in scope and application, but have the rehabilitation of damaged land in common. When introduced, their policy intent was not always clearly articulated, and in these circumstances must necessarily be inferred from the accompanying documentation and discourse. The mine site rehabilitation concession is a financial incentive provided to mining and quarrying companies to restore the mine site to its pre-mining condition. Its purpose was commercial, recognizing that such capital expenditure was necessary to comply with state legislation, but would not be tax deductible. However, following a series of amendments, it can be inferred that the current provisions do reflect an environmental purpose. Based on the above, no reference to the PPP is made in any documentation accompanying the introduction of or subsequent amendments to the Australian tax provisions dealing with the rectification of damaged or contaminated land. This does not necessarily imply that there was a conscious effort not to include the principle polluter pays. Nevertheless, merely because it was not explicitly incorporated does not mean that its application cannot be assessed. Based on the analysis, Australia's land rehabilitation tax concessions do not comply with or adhere to the polluter's pay principle. But there are similar legislations that sets out the polluter to clear up the contaminated land in the name of rehabilitation. Although the polluter pays principle is not applied, the Australian court's orders are somewhat similar to the PPP principle. Next, we would see the application of polluter pays principle through cases in Australia. An example of a case in which a court imposed a civil pecuniary penalty under the environmental statute is Minister for the Environment and Heritage versus Greentree. In this case, the Federal Court of Australia imposed a record of 450,000 AUD penalty on a New South Wales farmer and his company for illegally clearing a wetland of international importance, the Ramsar wetlands near Moree in New South Wales. The court fined Mr. Greentree 150,000 AUD and his company 300,000 for significant impacts caused to the wetlands and awarded costs to the Australian government. The court issued an injunction preventing Mr. Greentree from taking any further agricultural activity on the land and also from running livestock on the site until at least 2007. Mr. Greentree was also ordered to rehabilitate the site. Another example of a case in which a court ordered the restoration of an environment harmed by conduct in breach of a statute is Great Lakes Council versus Lani. The Land and Environment Court ordered the persons who cleared native vegetation comprising endangered ecological communities to refrain from future clearing, appoint a bush regenerator and an ecologist whereby the bush regenerator would carry out weed infestations, control measures, and remove timber, and the ecologist would install fauna nest boxes and carry out a baseline survey, pay the costs and expenses of the bush regenerator and ecologist carrying out such work, to provide the local government authority the instructions to and the reports from the bush regenerator and the ecologist. An example of another appeal case would be Landers versus Director General of the Department of Infrastructure, Planning and Natural Resources, where the Land and Environment Court affirmed a remedial work order and dismissed the appeal. Another example of an administrative order is in the context of contaminated land. Under the Contaminated Land Management Act 1997 of the New South Wales, the polluter bears the primary liability for the remediation of contaminated land for which they are responsible, including because they caused the contamination of the land. Lastly, we would move on to the protection of environment in Malaysia comparing to Australia. In Malaysia, it may be mentioned that the government in Malaysia is very conscious about the environmental development and conservation issues. In the meantime, some important environmental laws and policy, as mentioned in the above, are very much important for environmental development and conservation in Malaysia. The government may closely look into their interests and outcomes of the economy. The government should give more emphasis on the transparency and accountability of the administration along with the environmental organizations, particularly in the police administration and decision-making process. The Malaysian government has been working in line with some international environmental principles such as the precautionary principles, the environmental impact assessment, the polluter pays principles, English common law principles, global and regional participation, Islamic principles, the principles of the public international laws, and other laws governing the environmental development and conservation. Whereas, Australia does not have legislation establishing a statutory cause of action for recovery of damages for injury to or loss of publicly owned natural resources, such as the Comprehensive Environmental Response, Compensation and Liability Act 1980, also known as the CERCLA, or the Oil Pollution Act 1990 in the USA. Australia also does not have a legislatively prescribed methodology to undertake natural resource damages assessment, or also known as the NRDA. Nevertheless, Australian courts do undertake assessments of the injury to or loss of natural resources in determining a range of.
So now into the comparison between India and Malaysia. So first we'll be looking into the constitution of both countries. So in India, there is a word of environment clearly mentioned in the Indian constitution, and the responsibilities to protect and care for the natural environment are not only for on the state but also on its citizens by virtue of Article 48A and also Article 41A Clause G. In Malaysia, there is no word of environment stated anywhere in our federal constitution, but there are mentioned of words that can be associated with environment such as water, forest and land, and is vested on the power of state by virtue of second list of 9th schedule. Now looking onto the cases. So the environmental cases in India were being assessed with the recovery cost from the polluters to be one of the sentences imposed to the offenders. In the case of MC Mehta against Union of India, where the court in this case held that for the purpose of restoring the damage caused by the pollution, the polluters themselves should be liable for the cost of it. And in cases of Indian Council for Enviro Legal Action against Union of India, where the court in this case included the burden of the polluters not only for the cost for the restoration of the damages, but also to compensate the individual who subsequently affected by the pollution cost. And in the case of Fellow Citizen Welfare Forum against Union of India, the court in this case reaffirmed the importance of the polluter pays principle and declared for it to be part of the environmental jurisprudence of the country. In comparison to India, in Malaysia, generally the court sentenced the offenders with either fines or imprisonment or both, and the punishment imposed according to the limitations set by the Act. And for example, we can see from the case of Kwek Ging Hong against PP, where in this case, the accused was found guilty for allowing open burning of certain vegetation waste without license, and the court sentenced him with 6 months imprisonment. In this case, there was nothing of polluter pays principle was applicable in this case, may it be to discharge from him certain amount of or cost to recover the condition of environment after being polluted by him. And next, we'll be looking onto the enforcement and administration of polluter pays principle. So in India, the implementation are being done through various strict enforcement, such as through legislation. For example, in their Public Liability Insurance Act 1991, it is made an obligation for the industry with capital value of rupees 200,000 to get insured under the Act. The premium shall be collected under the Environment Relief Fund and shall be available with the collector of the district in case of industrial accident or disaster caused by the responsible industry. And also, by reference to the National Environment Tribunal Act 1995, it allows the tribunal to award compensation on any damages caused to the environment, and in failure of paying within a specified period, it shall be recoverable from the owner of areas of land. And also in India, they had established an environment protection fund where the cost for restoration of the pollution will be deposited. This fund is made readily available for the use of compensation to affected individuals and also for the purpose of restoring the damaged environment. In Malaysia, We found that the Section 47 Clause 1 can be said to come under the ambit of the definition of polluter pays principle. However, we are not sure if it really a polluter pays principle related laws, why the implementation in our countries is still unnoticeable. And we are aware with the Part 5A of the Environmental Quality Act 1974 regarding the payment of cess and environmental fund. It is mentioned that this fund is used for the purpose of restoration of the polluted environment as spelled out in the section 36E clause D. However, there was none in any of the section in this part mentioning that the fund is also consists of the money of whom the cost for the restoration of pollution is recovered. Therefore, from this finding, it is safe to say that the use of Malaysian Environmental Fund might be slightly different with the Indians one, as generally understand that the use of polluter pays principle is not widely applicable within Malaysia. Thus, a conclusion to the comparison between India and Malaysia, India is way ahead in the use of this said principle, while Malaysia might still taking its step in stepping the game and to adopt this principle to strengthen the aim and purpose to safeguard our environment.
Now we are going to look at the comparison of UK and Malaysia. Recently, the UK has decided to leave the EU. This incident shows that there is no enforceable environmental principle binding UK to EU laws as per the European Union Withdrawal Act 2018. So previously, I have explained that EU has codified PPP in the EU treaty that legally binds its members to enforce PPP as a law. Now that the UK is no longer a member of the EU, the UK can either choose to repeal any related law regarding PPP or maintain it. Now we are going to look at the case of Fishermen and Friends of the Sea and the Minister of Planning, Housing and the Environment, Trinidad and Tobago. I believe most of you may wonder why we chose this case because it is not a UK case. But bear in mind that Trinidad and Tobago is a member of the Commonwealth. And then this case was heard in the Supreme Court of the UK. And then we chose this case because it is quite recent, which is in 2017, and it highlighted PPP explicitly, so you guys can further read this case. Okay, let's move on to the case. So the government, which is a member of the Commonwealth, started an act of PPP. The country foresaw the need of the National Environmental Policy, NEP, and thus required all parties to act in accordance with the National Environmental Policy. The issue raised in this case was whether the local regulations recorded the charges were consistent with the NEP. Local regulations outline a fixed annual permit and base the amount upon the total cost to the Minister of issuing the permits, which he or she thought was going to have to issue. The appellant, which is Fishermen and Friends of the Sea, a local NGO, succeeded in contending that the charges was solely based on administrative costs, ADC, instead of the total cost, and did not comply with the PPP as per the NEP. The charges bore no relation to the pollution which would be caused by the permit if granted. Lord Canworth decided, first, the minister should allow for an additional amount to be used by the authority itself to correct environmental damage. Thus, higher amounts should be charged to polluters. It was not sufficient that polluters only spend its own money in complying with the permit conditions. Instead, should also contribute to the correction of environmental damage. The Environmental Management Authority then will use the fees to finance or contribute to correction activities. The court said that PPP is now firmly established as a basic principle of international and domestic environmental laws. It is designed to achieve the internalization of environmental costs by ensuring that the cost of pollution control and remediation are borne by those who cause the pollution, which are the polluters. And then this concept is actually an economics theory of market failure, which is externalities. This theory says that the societal cost is greater than the private cost and the societal benefit is less than private benefit. Essentially, it means that, okay, for example, company X is polluting the water, and then they are just dumping their waste inside the river, which means that the private cost is less because they have to manage the waste with less money. However, we as a society we have to bear with the consequences. Means that we have polluted water and then polluted air. So the cost is greater for us as a society. The court ruled out that costs and charges may be required as a result of an authorization to carry out a polluting activity. The court also commented that local acts, regulations and statutory policy will help to spread costs of pollution onto those who sought to pollute. So businesses as polluters could carry on their businesses as usual, provided that they pay the externalities created. The rationale of this law is obvious because minimizing pollution costs the business. Therefore, the system should make sure that greater polluters pay more than the lesser polluters. It can clearly be seen that the sophisticated system of turning the broad PPP into a way of making voluntary politics pay, and thus incentivizing any decisions to reduce their polluting activities. Looking at the current EU and UK system, we can see that many environmental principles such as PPP, precautionary principle, preventive principle and rectification of damage are embedded into the EU treaties that the UK are adhering to. These treaty obligations drip down to individual environmental measures, whether via EU directives or regulations and any domestic implementing the measures. So post-Brexit, Clause 4 of the Withdrawal Act 2018 ruled over rights like citizenship rights, free movement of goods, etc. However, it didn't do the same to treaty obligations. So on 12 December 2017, before Brexit, Michael Gove, member of the UK's cabinet, announced a consultation on a body to hold the government to account for post-Brexit environmental standards. He believes that the government would repeal all laws regarding environment which were created according to the EU treaties. Since that the UK is no longer bound by EU standard, they can choose either to repeal or maintain the laws that they have created while being with EU. Comparing to Malaysia, we have yet to enact and implement such law as stated in the comparison made between India and Malaysian law. As of today, the media has only reported that the government is considering law to make polluters pay for cleanups. Minister Yeo Bee Yin, the then Energy, Science, Technology, Environment and Climate Change Minister, said that law would be part of the proposed amendment to the EQA 1974. She said that the new law will also take into account of punishing companies that fail to monitor their scheduled waste movement instead of only focusing on individuals who commit the crime. As per the case mentioned in Part A, which is the fishermen Trinidad Tobago, Malaysia's EQA has also detailed those who can pollute with permissions in Section 21. If Malaysia were to implement PPP strictly as a law, Section 47 and 21 should be read hand in hand in determining companies who are responsible in paying the pollution cost. To conclude, we can see that it is quite clear that a well thought out Trinidad and Tobago permitting system makes the PPP a real law on the front line, granting permits to pollute, I mean. So the current EU and UK laws are doing the same. It would be fitting if Malaysia also adopt a version of the Trinidad and Tobago and EU-UK system in our current environmental law so that Malaysia is able to control the pollution costs and leverage PPP to cover the costs incurred for correction activities, just like what had happened in the case of the fishermen and Trinidad and Tobago.
As a conclusion, other countries such as India, Australia and the United Kingdom are far ahead of us in terms of making the polluters pay for their wrongdoing. We need a more severe punishment to serve as a deterrence. By applying the polluter pays principle, the amount of money which can be recovered from the offender might be higher than those amounts specified in the Act and can be exact amount of cost needed to reverse the condition of the polluted environment. It is important for us now to confirm with the legislative authorities whether they indeed intended Section 47 as polluter pays principle. If it is indeed a polluter pays principle, the next step is to properly enforce the law. If this provision is proven not to be the desired polluter pays principle after all, then it is vital for the legislative body to enact another good law to make the polluters pay for their own wrongdoing in polluting the environment. Thank you.